Hi guys, it's Kathy. I hope you're doing well. We made it to Sunday, Super Bowl Sunday. Yes. Go Eagles. I'm a Pennsylvania girl. I gotta say go Eagles. I have to. Since Pittsburgh isn't here, I gotta say Eagles. They're favoring the Chiefs to win again. But maybe Pennsylvania can, maybe. Maybe. Don't listen to Fozzie. He doesn't like green grapes. I mean purple grapes. Green grapes are fine for him, but not purple. Purple completely tastes better. Fozzie, I think that you should go to the store and buy one of those combo green grape, purple grape containers and eat one of each. I'm telling you right now, you're going to like the purple better. They just taste better. So, McDonald, in case you forgot, we're doing this little case, Michael McDonald. Michael Lee McDonald. Not to be confused with the cases of his brother, John McDonald. It's a snowball. It's a little piece of snow. Children go outside and do that for fun. Fozzie thinks snowballs hurt. They don't hurt. They're fun. It's a fluffy ball of snow. Oh my gosh, Eagles fans threw a tissue at the ref. Oh no. Oh no. I don't know how many of you got covered in snow. I don't even know if I got covered in snow. But I hope you guys are able to dig out and move along with your life like we are about to right now. Michael McDonald.
Main seating come to order, public 28's game session.
Okay, ready to go?
Yes, sir.
Yes, sir.
Please be seated. Okay, opening statements.
Thank you, Your Honor. Is this on me? Can you hear me? Try it. What's it on? Test. 1, 2, thanks. Michael McDonald was going to get what he wanted, no matter what it took. No matter what corners had to be cut, no matter what lies had to be told.
Objection, is there any evidence in this case?
Well, my words are not testimony.
His words are supposed to be directed toward what the evidence is going to show, not his opinion.
Unfortunately, ladies and gentlemen, the corners that he chose to cut, the lies he chose to tell, specifically where and how those
Your Honor,
lies
I
were
ask that
told.
a continuing objection to this opening statement be lodged. Does not
Make
any
sure
reference
you
to the
address
evidence.
what the facts will show.
Ladies and gentlemen, the
What a coincidence. Michael. Oh my gosh. Fear for Victoria, guys. Fear for her. I think it's the same Michael.
evidence will show that those corners that he chose to cut and the lies he chose to tell, specifically how they were told and where they were told, constitute felony criminal offenses. The next couple of days, you'll hear from various witnesses during trial. One of whom is a detective with the Las Vegas Metropolitan Police Department, Detective Aaron Stanton. Now, Detective Aaron Stanton is assigned to a specialized unit called the Criminal Intelligence Section. And what he and his unit do is probably a little different from what you might expect from police officers and detectives. They work generally with public integrity cases, which involves allegations and investigations about political corruption, specifically politicians or candidates who are running for political office, or other professionally licensed individuals like physicians, lawyers, judges, or other law enforcement officers. As part of that, what they do, among other things, is they monitor certain websites on the internet where allegations are commonly made in disdain. Politicians, other licensed individuals. And they follow up on those leads to determine if there's merit to those allegations. And that is where this case begins. In March of 2018, Detective Stanton observed some comments on one of those websites in regards to the defendant, Michael McDonald, who was at that time running for political office. Specifically, the allegation revolved around a residency violation. Somebody alleged that he didn't live within the district in which he was running. Based on that, an investigation was opened by the detective. The very next day, on March 20th, Detective Stanton found some additional allegations on another website. And these were about alleged forgeries in a family court case that the defendant was at that time involved in. Based on that, an investigation was furthered, and the detective found out that the defendant was at that time in a divorce proceeding with his now ex-wife, Candace, and that they had a family court case in which the defendant was representing himself, meaning he was acting as his own counsel. Litigation was still ongoing at that time, specifically revolving around child custody issues, and that family court case was assigned to Judge Linda Markey in family court. The evidence will show, and you'll hear from various people, you'll see various documents. We'll try to make clear what those documents mean, and eventually you'll have those documents and evidence to hold and look over for yourself. But the evidence will show that on September 27, 2017, the defendant filed a motion in his family court case. This is the first page of that document. You can see in the top left corner the defendant's name and that he is in...
Objection. Why are we looking at evidence? It hasn't been authenticated, it hasn't been admitted.
Counsel approach. Sustaining the objection.
And eventually you will be able to see these documents for yourself. On September 27, 2017, the defendant filed a motion in family court in his divorce proceeding case. Attached to that motion was a document that will become very important in these proceedings. It was a letter from the defendant's therapist, Nancy Hunterton, married family therapist. The letter described what she was meeting with the defendant for, that they were talking about issues related to divorce and the children, and that she had been seeing him since June 2017. That was attached as an exhibit. December 4th, a couple weeks later, 2017, the defendant files another motion, and attached as an exhibit is that same letter. But this time, the letter has one key difference, and there has been a sentence added to the bottom of that letter. It says, "I do not believe Mr. McDonald is a harm to his children or himself." A couple weeks later, December 20th, 2017, the defendant files another motion in that same case. The original unaltered letter is attached as an exhibit without the added sentence. A couple months later, in March of 2018, a hearing has been scheduled for the 16th, and it's based upon kind of the litigation ongoing, some of the motions that have been filed, and in preparation for that hearing, the defendant files an exhibit list, which is filed in its official court document. Part of that exhibit list is, again, the letter from the therapist. This time it is the altered or forged version. And it includes the sentence at the bottom. I do not believe Mr. McDonald is a harm to his children or himself. On that same day,
Same. I love that song.
within that same packet, the defendant files a general financial disclosure form wherein he kind of outlines what he does for a living, how much he makes.
Sarah, yay.
He says in that document, or that list of documents, that he has no income other than $800 a month from odd jobs. He lists his last employer as Geotab, which he says ended in February of 2017, over a year ago. And he also states that he does not have a current employer, and that is filed as an official document.
Debbie, you made it. Hi, Debbie.
3 days later, the hearing goes on as planned, and the defendant is sworn in under the penalty of perjury. You'll see a video where he does that, promises to tell the truth. During that hearing, he testifies again that he makes $800 a month from odd jobs. He also testifies that he filed the exhibit packet, including the financial disclosure form, which was spoken about in the previous slide. On March 21st, 2018, the Detective Stanton, based on his investigation, meets with the therapist, Ms. Hunterton. And he asks her about these two different letters. He shows her the forged letter and asks her if she recognizes it. She compares that letter to the letter that she had prepared and is still in her personal file for her client, for the defendant. And she recognizes to the defendant that she knows the original that was filed on September 27th and December 20th. But she says she does not recognize the forged letter, or the letter with the added sentence, that was filed on March 13th, 2018. Also, on March 21st, that same day, the defendant files another motion. And in that motion, attached as an exhibit, is the forged therapist letter, the third time it has been filed in a court docket. On April 11th, based upon the investigation by the detective, he obtains a search warrant for the defendant's residence. They go to his residence, they speak with the defendant, they talk to him specifically, obviously, about the forged letter. And the defendant makes excuses about how the wording should have been there anyway, and that my therapist would have allowed it. The defendant would not, however, admit to having actually added the sentence.
Yay.
The defendant voluntarily shows the police his Google Drive, which includes obviously all his paperwork. Within that drive, there are copies of the original letter as well as the forged letter. They also search his car, which is parked out front. Inside is a binder with all his litigation paper, all the exhibits, all the motions he had filed, and among those is the forged letter. During that search warrant and the conversation that the detective has with the defendant, eventually the detective offers, maybe we should call Ms. Hunterton and ask her, because you're alleging that she would have written this or she gave you permission. So they call her on the phone, on speakerphone, with all three of them present. And she says that the original letter came from her office. She says the altered letter did not. She says she never gave the defendant permission to alter that letter. And she says that there was at one time communication with the defendant about possibly writing an additional letter in the future, which never happened. After the search warrant, on April 19th, 2018, this is about a week after the search warrant happens, the defendant goes to Ms. Hunterton, his therapist, and asks her to prepare an affidavit, which she does. In her affidavit, she states that, yes, I wrote the original letter. She states that she would have written the letter with the sentiment about the defendant not being a danger to his children if she were given the opportunity. That same month, in late April of 2018, Detective Stanton finds something else very important. He discovers that the defendant has current employment at a place called Progistics. He finds out further that the defendant has worked there since October 23rd, 2017, that he makes approximately, as a salaried employee, $47,500 working in the IT department, and that as of April 30th, he was still working there. There was no lapse in his employment between the October 2017 and April, while he was put under oath and said that he was unemployed. This all falls within that spectrum when he was full-time employed. His net take-home pay every 2 weeks is over $1,800, which means He makes approximately $3,600 a month. You will hear from additional witnesses in this case. You'll hear from Kristina O'Connor, who works for the 8th Judicial District Court Clerk's Office in regards to some of the filings that you will see later. You'll hear from Nancy Hunterton, the therapist that was mentioned. You'll hear from Brett Zagaski and Timothy Spies, who are both marshals who work in the courthouses. You'll hear from Lisa Smith, who works in the HR department at Progistics, where she dealt with and spoke with the defendant on a daily basis while he was employed there. You'll then hear from Detective Stanton, who I've mentioned is the lead investigator on this case. And finally, you'll hear from Marshall Willick, who is an expert in family law. After you have heard from these people, and you have seen the evidence and heard the evidence, you will come to the obvious conclusion that the defendant is guilty on all counts, which include multiple counts of burglary, forgery, perjury, and offering false instrument for filing or record. Thank you.
Ladies and gentlemen of the jury, Mr. McDonald hasn't done a thing wrong. Detective Stanton is what you would call, and the evidence will show, what you call is a politically correct enforcement division of the Sheriff's Department. Mr. McDonald is getting divorced. That's unfortunate. Most of you were asked about during jury selection if you'd been through a tough divorce. Mr. McDonald's divorce is going just fine, such as things go. His attorney, God rest his soul, received about a $5,000 retainer from Mr. McDonald, and then, for whatever reasons known only to him and God, committed suicide, leaving Mr. McDonald without money and without an attorney. $5,000 gone. Mr. McDonald has no attorney, and he now has to represent himself. And I asked, and you'll hear, about having to represent yourself in a lawsuit. He's now got to represent himself. His wife, ex-wife, uses that opportunity for Mr. McDonald, who doesn't have an attorney now, to file a restraining order and to take away the kids. Mr. McDonald has no attorney and no money and has to go in and represent himself. And Judge Marquis sees fit to take away his custody visitation. No contact with your kids because your ex-wife said no. No lawyer, no money, no attorney, no kids. Not surprisingly, he's not particularly happy with that outcome. He complains about it. He decides that he's going to run for office on the platform of reforming family court based on the treatment that Mr. McDonald has received at the hands of family court. Knock on the door, in shows the state's police. Your papers, please. We want to see, based on an anonymous report on a website called Nevada Court Watchers, Detective Stanton gets an anonymous tip. So he goes over and knocks on Mr. McDonald's door to find out if he actually lives at the location. He isn't from the Secretary of State who runs the elections. He's not from the court recorder's office. A local county sheriff in the political crimes unit, Detective Stanton, goes into Mr. McDonald's house to verify he lives there, based on an anonymous tip. So when he finds out that Mr. McDonald does in fact live at the address he's registered to run for office at, that's not good enough. It's political crime season. We're going to find something wrong. So then they go in and they start going through Mr. McDonald's pro se. He's pro se doing complex civil litigation. And they start combing through dozens, if not hundreds of pages to find something wrong. Something wrong. And what did they come up with? 3 days before a report was due, Mr. McDonald went and met with the family therapist. She didn't put in the exact language that was needed, which is specifically that he's not a threat to his kids. He calls her up. She says, oh, okay. So, not being an attorney, he writes it in and turns it in. And what she was going to testify to, what she's previously testified to is, yeah, what's in this report is correct. I didn't write it, but I agree with it. So there's no forgery. You don't have a crime. There's no intent to deceive. That's the evidence. So, when that case comes out, then Mr. McDonald, now without a lawyer, and without any money, and without his kids, now going on 3.5 years, files his financial affidavits. They file them in or September, and the hearing gets kicked to March. And as you heard from my colleague, the documents, when filed, were in fact correct. Ladies and gentlemen of the jury, what you're going to see here is the most blatant exercise and abuse of police powers that you can imagine in the United States. A citizen goes down and files for office, and his reward is a county sheriff doing a search warrant on his house based on an anonymous tip on a court-following website. And you're going to hear from Mr. Willett, a primary participant in that website, and it's a website where all the family court lawyers and judges talk to each other anonymously. And you're also going to hear that it was actually shut down because it was interfering with the good order of justice in the family court. Now, there's a reason you're here, ladies and gentlemen. The reason is you're going to need to vindicate the legal system and protect them, and protect Mr. McDonald from politically correct, picayune, dishonest, intellectually dishonest enforcement of law. The evidence is going to show he's entitled to a not guilty on every count. Nothing wrong here. This is the governmental establishment upset with someone who had the temerity to run for office and to complain about how he was treated by a family court judge. And that is why when you listen to those documents, you watch those and you think about yourself, hey, I need a lawyer.
And through all of that, nobody objected to his opening statement. He's a jerk.
Yeah, you do. Where was he? He's dead. What happened? He's got my $5,000. I've got no lawyer. And now Mr. McDonald is sitting here, and you need to find him not guilty, and the evidence will support a finding of not guilty on every charge.
Thank you. State, call your first witness.
Can we have the pulpit turned here? Your Honor, while they're doing that, before we call our first witness, the state would move to admit Exhibit 1, which are certified court minutes from the hearing from March 16, 2018. They've been authenticated and certified, and we would move to admit them under NRS 52.125.
May I see them, please?
Do it yet, moment.
I object. There's this is that.
All right, the objection is withdrawn. The document will be admitted. What was
Exhibit 1, Your Honor.
Exhibit 1?
The state calls Kristina O'Connor.
I did get comments, guys. I got comments. Are you ready for this? Hold on. I'm getting it. Alright, here's the first one. Parental alienation is really a thing with these females. No, man, you have to go through this to see his children. No, man, you have to go through this to see his children. This is why I did not suggest getting married in this era. You stand and lose more than you gain. And, hold on, there's a better one. Hope them kids find out how much their father tried to see them and resent their mother for it. Yeah. We all watch the same thing. And those are some of the comments I got.
You do solemnly affirm the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, under the case of penalty of perjury. Thank you. Please be seated. And will you please state and spell your first and last name for the record?
It's Kristina O'Connor, K-R-I-S-T-I-N-A, O''C-O-N-N-E-R.
Thank you.
Go ahead.
Good morning, Ms. O'Connor. Can you tell the members of the jury what you do for a living?
I'm the court division administrator for the family court clerk's office.
Is that in the 8th Judicial District Court
Absolutely.
Family Division?
Yes, it is.
Can Where's the family court
Why?
located?
What does it
At
say?
601 North Pecos?
Is that in Clark County, Las Vegas, Nevada?
Yes.
Well, court division administrator, how long have you been in that position?
I've been in that position just over 7 years.
And if you can, tell us what some of your duties are in that position.
I oversee the entire family court clerk's office, which includes our customer service windows, the court clerks, our e-filing units at that time, also the records divisions, child support, any of the clerical duties.
How many court clerks are employed at the family court building?
Just court clerks or court clerk staff, meaning, because they're all titled court
Okay,
clerks
so
per se.
Paul, how many specific court clerks?
I don't know the actual court clerk number off the top of my head.
Okay, approximately how many employees then do you oversee?
I oversee approximately 103.
103?
Yes.
And just to kind of clarify what you listed as your duties, as part of your job, do you regularly review court filings and court documents and court records that people file in that building?
Yes,
Specifically in family court cases, is that correct?
correct.
So, if I can, I'm going to ask you some questions about the process of filing court documents, okay? Can you walk us through how a person files a court document?
There are a couple ways to file currently. You can either electronically file them through our File and Serve program, or you can also come into either of the locations of the clerk's office at both family court or the RJC and file documents across the counter.
When you say RJC, is that the Regional Justice Center?
Yes,
Are we currently standing in the Regional Justice Center?
yes,
Okay. Is that at 200 Lewis Avenue, Clark County, Las Vegas, Nevada?
yes,
Okay. So people can file family court documents here at this courthouse, is that correct?
correct.
Okay. You also said you can do it in person here at family court, but you also said electronic filing. Where does that take place?
You can either electronically file from an outside area, you register for an account, or you can also use kiosks that are located in our lobby at the family court location.
And who can do that? Who can file?
He's not whispering to this
Is there any
attorney.
limitations?
No.
Let me ask you this. When you file a document which would be considered the original, who keeps the original?
The original is through the customer service counter, can I?
Yes, if you do it in person, yes.
If it's through the counter, the filer keeps the original, and we scan that into the system.
Okay. If for whatever reason they lose that original or just need another copy that is certified or authentic and can be used in a court proceeding, how does somebody certify a copy as to be used in court?
They would come to our customer service counters, do a records request,
Okay.
and then request a certified copy from the record, and then pay any required fees.
And what goes into assuring that it's a certified copy? What is that process like?
I need you to clarify that a little bit, sorry.
Do they compare it to another document, or do they stamp it? How does that process work?
If the customer doesn't have a copy of it, we print the copy out of the case management system, and then we certify that document directly out of the case management system.
And when you say we certify, what do you physically do to certify the document?
Not just jail staff stopped him. The administrator of the daycare has her child in the daycare. He grabbed the administrator's child and started walking towards the door. And the administrator, the mother of that child, saw him. And everybody stopped him from taking that child, her child, out of the daycare.
The clerk knows at the counter that they printed it directly out of the system, so then they will take any required filing fees that are for that. They stamp it with our certification stamp, and make it embossed, and then I believe they sign their name, but I don't need to double check.
When you say embossed, does that mean there's a kind of a raised insignia? Okay. And when you've mentioned file stamping, where on the document is a file stamp located?
For when the document's filed,
Yes.
it's up in the upper right-hand corner.
And what information is included in the file stamp?
It would be the date, in some cases the time. It states it was electronically filed. It has the clerk of court's name on it. I believe that's it from off the top of my head, not seeing one in front.
So you said the date, and then you said sometimes the time. Why would it not include the time?
It depends on how it gets filed. So currently, the way our system's set, that is if a document gets electronically filed through our file and serve program, then it will include the time that it was submitted into it. If the document is coming across our counter, it does not have the time associated on that file stamp.
Okay. So if somebody does it at a kiosk in the lobby, it'll have the time stamp.
Correct.
Okay. Or if they do it from another location that has been permitted to do that.
Correct.
Okay. Are there, in the various rooms, the courtrooms at the Family Justice Center, or the Family Court Center, is there a video surveillance
In the
in the family court hearing rooms down at the family center?
Do you mean the JAV system?
Okay.
Which records the hearings?
Okay, so when you say JAVS, what is JAVS?
It's the Jefferson Audio Visual System. It actually records hearings.
Okay, and audio and visual?
Yes.
Okay. We've been referring to the family court. Is it sometimes referred to, or is it properly Family Courts and Services Center?
That is the location, yes.
Okay. Brief indulgence. Do you also, we've talked about court documents and proceedings, do you also review and certify court minutes as a part of your job sometimes?
My staff do, yes.
Okay. Can you explain what are court minutes?
Court minutes are a summary of what occurred during that hearing.
Okay. So it would include the date and time of the parties present and what occurred during the hearing? Permission to approach, Your Honor? Just a... Showing defense counsel, Your Honor, the state's proposed exhibits. I believe it's 2 through 7. 2 through 6. 2 through 6, thank you.
What exhibit number is that?
I've taken all of them. I'll put it on the record as I approach, Your Honor. May I approach?
Go ahead.
Thank you. Okay, Ms. O'Connor. I'm showing you a court exhibit number 2. Pardon me. Court exhibit number 1. What does that appear to be?
It appears to be a certified copy of a document that was filed on September 27th of 2017.
When you say certified, I saw you flip it back to the, does it have the emboss on the back page?
It does, yes.
Okay. Showing you proposed exhibit 2. Showing you proposed exhibit number 2.
Sort of. His attorney is a jerk enough that it's okay.
What is that?
It appears to be a redacted copy with a similar appears to be a redacted copy of it.
When you say redacted, there appears to be a lot of black on those
Correct.
pages. So does it appear to be a redacted version of the certified copy on the left?
It does, however, the redacted copy has the time associated in the file stamp and not on the copies that was certified in 2018.
Is the date the same?
The date is the same.
Okay. And the parties and the title to the document, are those all the same? It's a lengthy title, sorry.
Yes, no, that- Yes, they appear to be.
The state would move to admit state's proposed number 2.
That would be the redacted copy?
Yes.
Okay.
Will be admitted.
Showing you court exhibit number 2, as well as state's proposed 3. The same question, the court exhibit, what does that appear to be?
A certified copy of the document that was filed on December 4th of 2017.
And is state's proposed 3, does that appear to be a fair and accurate copy, but with the majority of the document redacted?
Yes.
Move to admit state's proposed 3, Your Honor.
No objection.
Will be admitted.
And for the record, that is the redacted copy.
Yes.
Okay. There you go.
Showing you court's exhibit number 3. What does that appear to be?
A certified document that was filed on December 20th of 2017.
And showing you state's proposed exhibit 4, does that appear to be a redacted version of the same?
Yes.
The state would move to admit the redacted version, which is state's proposed exhibit 4.
Objection.
No objection.
Will be admitted.
Showing you court's exhibit 4, what is that?
It's a certified copy of a document that was filed on March 13th of 2018.
And showing you proposed exhibit 5, does that appear to be a redacted copy of the same?
Yes.
State moves to admit the redacted version, which is state's proposed exhibit 5.
No objection.
No objection to the redacted copy.
Will be admitted.
And finally, showing you exhibit 5, what does that appear to be?
A file stamped certified copy of a document filed on March 21st of 2018.
And showing you state's proposed exhibit 6, does that appear to be a fair and accurate copy of the same, but with the majority of the document redacted?
Yes.
The state would move to admit the redacted copy, which is the state's proposed exhibit 6.
Any objection?
No objection.
Will be admitted.
Jump back to the pulpit. Sorry.
Thank you.
Permission to publish Exhibit 3, Your Honor?
Go ahead.
So what we're looking at is what been previously admitted as State's Exhibit 3. You can see on the bottom the redactions. We talked earlier, Ms. O'Connor, about file stamps. Can you describe to us where on this document the file stamp is?
In the upper right-hand corner.
Okay. And you can actually use your mouse there in front of you, I think. Does that give you a little bit of... Okay. So you're pointing to the top right of the document where it says electronically filed. Is that correct?
Correct.
And what is the date on that?
December 4th of 2017.
And the top left, who is the party filing that document?
It's listed as Michael McDonald.
And I know you described this earlier, but when it says electronically filed, what does that tell you?
Both of our file stamps will stay electronically filed.
Okay.
Because that's how they get entered into the system.
But the fact that this doesn't have a time also next to the date, what does that tell us?
That tells me that it indicates that it came across one of our customer service counters.
Publishing State's Exhibit 2. You can also see here that we've talked about the redactions there on the bottom. This is the front page. What does the file stamp there tell us about this document?
That it was filed on September 27th of 2017 at 8:02 a.m.
And who is the party filing this motion?
It's listed as Michael McDonald.
Bring it over. Republishing State's Exhibit 3, which has been previously admitted. Did you review documents associated to, and records associated to this document to determine where it was filed?
I did.
And I ask that because the file stamp, does that tell us where it was filed? Meaning the RJC, the Regional Justice Center, or the Family Court Building?
It does not.
Okay. But in your capacity and under your purview with your job, you're able to determine those things?
Correct.
And according to your research, where was this document filed?
I made some notes because it's been a long time since I looked at it. Would it be possible to review the note on the date?
Do you have your notes with you?
Yeah, it's just a piece of paper.
An objection is to review notes without proper authentication.
You can lay the-
Your Honor, this would just be refreshing recollection. He wouldn't be reading it out loud to the jury.
Show it to defense counsel.
Having seen it has been filed.
That's,
I don't have objection to her reviewing the notes and refreshing the recollection for whom she'll testify that she made these when the information was refreshed. I would also ask that a copy of this document be made and put as court exhibit.
that's fine.
Do you want me to lay a foundation for that, Your Honor?
I insist.
Is that, okay, I'm just making sure. So I understand you're looking at a piece of paper, is that correct?
Yes.
Okay. Is that your handwriting on the piece of paper?
Yes, it is.
You made those notes yourself?
I did.
And was that made during your research regarding certain filings For this case?
Yes.
Move to admit, Your Honor?
It's not being admitted, it's just
Or
used for...
just to be used to refresh recollection, is that
It hasn't
sufficient of a foundation?
It's my opinion.
That's correct. My colleague hasn't established that it does in fact refresh her recollection for that she actually knew it at one time.
And I think, Your Honor, there's some confusion.
Objection,
There were-
one witness per attorney.
I'm sustaining.
That's fine, Your Honor. Looking at these notes that you made yourself in regards to this case, does that refresh your recollection?
Yes, for the date.
Go ahead. I'm overruling the objection, assuming that's what your objection was.
No, if the foundation is properly lit, you should refresh recollection, I would probably
Okay.
no.
All right.
Ms. O'Connor, going back to State's Exhibit 3, that's being published here, where was this, according to your research, where was this document filed?
This document was filed at the customer service counter at the Regional Justice Center.
Showing Exhibit 4, which has been previously admitted. What does the file stamp there tell us about this document?
That it was filed at one of our customer service counters,
And what date was that?
December 20th of 2017.
And again, who is the party filing that document?
It's listed as Michael McDonald.
And publishing State's Exhibit 5, which has been previously admitted. Same question, Ms. O'Connor, what does the file stamp there tell us about this document?
That it was filed on March 13th of 2018 at one of our customer service counters.
And who is the party filing that document, according to this?
It's listed as Michael McDonald.
Showing you State's Exhibit 6, which has been previously admitted. Same question, what does that file stamp tell us about that document?
It was filed on March 21st of 2018 at one of our customer service counters.
And again, in regards to this document, do you recall where this was filed?
I believe on this document, it was filed at the family court's location.
Your indulgence, Your Honor.
Your Honor, I could put a few finer points. She said believe. Does she know? If she believes, then I move to strike.
Are you objecting?
Yes. There's no penalty.
Sustaining the objection.
Thank you, Your Honor. You say you believe, Ms. O'Connor. Were you also, did you do some research to try to determine where this document was filed?
Yes,
And what was the result of that research?
at the family court location.
All right, withdraw.
And I apologize, going back to State's 5, which has been previously admitted, the same question, Ms. O'Connor. According to your research into the history of this document, where was this document filed?
At the family court location as well.
We spoke a little bit about the JAVS video surveillance system that is in the courthouse and at the family courthouse. Were you asked at one point to obtain or pull video from a hearing that occurred on March 16th, 2018?
Yes.
And was that in relation to Michael McDonald, the defendant in this case?
It was in relation to that domestic case number, yes.
Did you in fact make a copy of that video and get it to my office, the district attorney's office? Did you then meet with myself and Ms. Mishler and view portions of that video that had been redacted and kind of cut down and view that in its entirety with us?
Yes.
Permission to approach it? Or I'll show defense counsel. Permission to approach?
Yes.
Showing you state's proposed exhibit 7. What does that appear to?
A CD of the snippets of the Jacksons that you have in view.
When you say that, how do you know that? Is this, what are we looking at here on the bottom of the disc?
Those are my initials and the date that I reviewed them.
Did you in fact write that yourself?
I did.
And was that after you viewed what's on this disc in its entirety, me and Mr.'s presence?
Yes.
Move to admit proposed 7, Your Honor.
Objection.
Are we going to show it to the jury?
I'm sorry?
Are we going to show it to the jury?
If it's admitted, yes.
Okay, then you want to show it to it? Okay.
It'll be admitted.
Thank you, Your Honor. Appreciate your diligence. Nothing further, Your Honor?
Cross.
Sam, you worked on the family court for a number of years, have you not?
I have, yes.
Okay. And
For those of us who don't get down to family court so often, can you explain a few things to me if you don't mind?
Okay.
Is it common for people to have attorneys in family court?
We do see attorneys, but the majority, I think, of folks also appear in proper person.
And when you say proper person, what does that mean?
They're self-represented.
All right, they're self-represented. That means a lot of people can't afford an attorney. All right. Now, how many documents a day do you guys take in down there in family court? Just in there's 100 or 1,000 will be fine.
It really fluctuates depending on the day. And can I ask, do you mean across the counter or just total?
Divided by other working days. I'm not interested in day after holiday or anything. I mean, just how many documents a day do you guys process down there?
Approximately 2,000 to 3,000.
2 to 3,000 documents a day. So how many working days a year?
I don't know that off the top of my head.
So we got 52 weeks, about 3,000 documents a day, give or take. You know, would you agree with that there's about 750,000 documents get filed with family court every year?
I don't know that off the top of my head.
Do you remember when I asked you about this at the preliminary hearing?
I don't actually, I'm sorry.
Okay, so you would agree 3,000, 2 to 3,000 documents a day?
Approximately, yes.
Okay, and they can be filed from the family court. They can be filed from this building down to family court, which is actually not here, correct? Now,
going through, counsel, where's your exhibit? Showing you State's Exhibit 2.
okay, what date was that filed?
September 27th of 2017.
Okay, and this is for Mr. McDonald to try to get custody visitation with his kids, correct?
I don't know the substance of the document.
Don't know the substance. And when was this document filed?
March 13th of 2018.
And this is actually just exhibits to the case, exhibit list, right?
That's the title of the document, yes.
Right. Now, there's a term here, and I want to understand something, if you can help me understand. The term here is on the top, it's called recusal. What does that mean?
I guess I'm not understanding the question.
I'm trying to make it as simple as I can. What does, the very first
term, or first word in the upper left corner of that particular document is the word recusal.
Correct.
Could we hear what exhibit number we're talking about?
Certainly, Counsel, I apologize. That would be States 3. Okay, the word again is the word recusal. The document date is on the 12th of, or 4th of March 2017, 4th of April, try again, 4th of December 2017. Now, what is a recusal?
Recusal is usually a request to have the judicial officer assigned to the case recused.
Okay, to get the judicial, and without, for the non-lawyers here, a judicial officer would be a judge. Correct?
Could be, yes.
Yes. And there's, so basically that document is a motion to recuse a judge. That's what its caption reads, correct?
Yes.
Right? And showing you what's been marked as proposed exhibit number 4. This document is called the reply. What's the caption here?
Defendant's reply to response to motion to disqualify and counter motion.
Okay. Now, I'm going to go out on a limb here, but I suspect sometimes down in family court, the motions run pretty high. Correct? I mean, you did down there a number of years. All right, and I would suspect people getting frustrated, maybe throwing things and kicking things happens fairly frequently, correct?
It can happen.
All right. Now, you can't say for sure who actually filed those documents, only that they were in fact filed.
Correct.
Now, I'm a little confused. If I had ill feelings towards somebody, could I go down and just file something in their case?
We don't require ID if
Okay.
you're filing at any of our customer service counters.
So if I wanted to file something that was kind of really unkind about somebody or something, I could, and I wanted to cause some mischief, I could go down and just file something in an electronic file, correct?
It would be processed through.
All right. Well, let me ask you a question. What is a fugitive document?
I'm not fully comfortable on the definition of that term.
Okay, well, if I'm representing somebody as an attorney, and they're not happy with me, and they file their own motion without telling me, are you allowed to accept that?
As a clerk's office, we're required to accept any documents that are filed. It's up to the judicial departments to make any decisions.
So it would be the court, the department, that would actually reject a document that was not proper.
Correct.
All right, is that the fact what they mean by a fugitive document?
It's my understanding, but I'm not confident on the full definition of that. It's not something we normally handle.
Now, you down in family court every single day, correct?
Well, every single day is kind of broad. I have staff at other locations.
I'm assuming they give you a day off. That wasn't what I meant. They do it when you're at work day. This is what you do. You get up, you go down to family court and run the clerk's office.
I do.
Okay, so that's what you do. Now, are you familiar with an organization down there called Nevada Court Watchers?
No, I'm not.
No. Do you ever get on the internet and read up on family court at all?
No.
Okay, so nothing that you do.
Mr. Miller, excuse me, we need you to put the lapel mic on. You're wandering out of areas where she can't pick you up.
Not a problem. No one will ever complain they can't hear me. He's not voice. All right, now that I got the microphone on, I think I'm just about done. Give me a moment or two. Now, if someone's attorney dies or they don't no longer have representation, is there ever a family court that teaches them how to do anything? How to file motions or how to put things together?
I don't know the answer to that.
Okay, so you're the technician behind the clerk's counter. You make sure everything goes where it's supposed to, but you don't actually get involved in the functioning of the court.
Not in the question that you posed to me about training people.
Okay. So
That's not a function that the clerk's office does.
nothing, right? And nothing that you oversee. All right, and since you're down in that building every day, do you know, is there a section somewhere in the building where you can send people who need advice? Right? And what is that section called?
It's called the self-help center.
All right, and so by law, by getting divorced and I don't have any money and I want some help from you with the clerk's window, are you allowed to give it?
We cannot give legal advice, no.
All right, so, look, tell me, what am I gonna do? And I'm upset and I'm nervous because, what is your response? What's the clerk's standards response to that?
If you drive a car through a parade and you spend the rest of your life in solitary, I am not bothered by that, not even a little bit.
We would refer them over to the self-help center.
Okay, and what exactly is the self-help center?
It's a office area that's located, the family self-help center is located at the family court location.
And in family court, do cases occasionally get rescheduled?
Continue.
Yes,
Is that-
continue to reschedule. Say the judge wasn't feeling well or somebody was in a car wreck on the way to court, do they get rescheduled?
Yes, I believe so.
All right, and you routinely have to reset court dates?
My staff do, yes.
Your staff does, I know. You, that's the royal you and your staff. Okay, I apologize. The royal you. All right, as your office, one of the things you do is reset court dates when things have to be changed.
Correct.
Now, sometimes people file documents and the file and the contents of the documents, what was true when they were filed necessarily isn't true in the future, correct?
I don't know on that.
Don't know. If I tell somebody I have no money in my family court filing, I file myself, and then I win a $1 million megabuck machine 2 days later, do I have an obligation to update that information?
That I don't know.
You don't know. All right, do you ever see updated financial information filed?
Yes.
Okay, so it does happen. Okay,
Is it a yes?
Yes, I'm sorry.
Shaking your head doesn't come out on the audio.
now,
This video
I
is
asked you
boring.
before, when you testified at a preliminary hearing, this is the first time you've ever testified in a criminal case, correct?
Correct.
And how many years have you been doing this?
And with the clerk's office?
With the clerk's office?
7 years.
7 years.
Just over 7
And you're
years.
7 years in charge?
Yes,
Okay, and then before you were in charge, presumably you worked your way up through the ranks,
correct.
all right? And how many years in the clerk's office total?
I don't know that number off the top of my head.
Okay, what year did they hire you?
Well,
Oh
I've been
no,
with the courts just,
I was unmuted, I'm so sorry. I wouldn't know because I keep losing focus of what's going on because it's boring.
just over 21 years, but I've worked in a multitude of areas.
All right, and in the clerk's office, how long have you worked there?
In the past, I honestly can't give you that number. I don't know off the top of my head.
You don't know how long you worked in the clerk's office? Within a few years. Okay. I have nothing further.
Redirect. Rebuild, sir.
Before I get scolded, I'll put the microphone back up on the podium.
Just very briefly, Your Honor. Ms. O'Connor, you're not a lawyer, correct?
No, I'm not.
You didn't go to law school? There was a question asked about, you obviously can't give legal advice, but there is a self-help center.
Correct.
Are you aware, is there other places in town that offer free advice and free help to broker litigants?
Yes.
Nothing further, Your Honor.
Nothing further.
Questions from the jury? Raise your hand if you have a question. I don't see any questions. Thank you. You may step down.
Watch your step when you come off, Mr. Conley.
Yeah, Steve, can you get the back?
Anyone else?
on any subject connected with this trial, or read, watch, or listen to any report of, or commentary on this trial, any person connected with this trial by any medium of
Kurt.
information,
Kurt, don't rewind it. It's so boring today. Just start from here.
including without limitation, newspapers, radio, television, internet, do not form or express any opinion on any subject connected with the trial until the case is finally submitted to you. We'll see you back here at 1 o'clock.
Folks, please leave your notebooks and pens. Leave your notebooks and pens. Make sure that you got the items
rise for the jury.
for lunch. You'll let you out.
Yep, that's me, a professional. We're watching a true professional, and then I do this. I don't know why this one is partway watch. I don't know if this is what we just saw. Hold on. Yeah, we just saw part 1, September 3. So we're on part 2. I'll rewind it.
Thank you.
Remain standing, face the clerk in court.
Please raise your right hand. Do you do solemnly affirm the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth?
Sorry, guys.
In the case of penalty of perjury. Thank you. Please be seated. Will you please state and spell your first and last name for the record?
Nancy, Nancy, Hunterton, Hunterton.
Thank you.
Okay, this should be better. This is the woman he falsified her document. And as a counselor who deals with court cases, the fact that he falsified her document, her words, and presented it to the courts, she should have a huge problem with that. And her just saying after he did it, oh, I was going to say that anyway, so it's okay, I have huge problems with. That is not professional. We're relying on her words as her expertise, and he just added words. And she's like, oh, yeah, that's perfectly fine.
Hunterton, what do you do for a living?
I'm a marriage and family therapist
And how long have you been a marriage and family therapist?
for more than 20 years.
And what's the name of your marriage and family therapy practice?
Character Way.
And do you have, can you describe the certification and educational background you have for that position?
Yes, to be a marriage and family therapist, you have to have had a bachelor degree and then go on and get a master's. And I am, I have a recommendation to take the state exam because I had a previous master's and I had been a certified therapist in another way. So I actually don't have a master's in marriage and family, but I am fully licensed and I am a supervisor of other younger therapists.
And so are you considered a licensed marriage and family therapist?
Correct.
And even though we all probably have some idea kind of what you do, but could you give a brief synopsis of just sort of what you do as a marriage and family therapist?
Okay, marriage and family therapy is a bit different from social work or some other counseling fields in that it is systemically focused. It looks at people in the context of families. So it is looking at marriages, couples, interrelationship between parent and child, and that kind of thing, but it always looks at people in the context of relationship.
And through your work as a therapist, are you familiar with a person by the name of Michael McDonald?
I am.
And do you see Michael McDonald here in the courtroom today?
I do.
Could you please point at him and describe an article of clothing that he's wearing?
He is the middle gentleman at that table, and he is wearing a blue striped tie, blue and gray, I think.
Jacket or no jacket?
No jacket.
Your Honor, may the record reflect the witness has identified the defendant?
It will so reflect.
And how are you familiar with the defendant, Mr. McDonald?
Mr. McDonald came to my practice to be seen as a client.
And is that the term you prefer, client rather than patient?
Yes.
And so
She calls them all
So while
Johns.
Mr. McDonald, the defendant, was your client, as a result of that, did you become aware that he has an ongoing family court case?
Yes, I was aware of that.
And at some point, while the defendant was your client, did he ask you to write a letter for him?
Yes, he did.
And did you then prepare a letter for him?
I did.
And what was your understanding of the purpose of that letter?
It was to acknowledge that he had begun counseling with me.
Okay. And did you have an understanding of what the defendant was going to do with the letter?
That he would present it to the court. I believe I directed it to the court.
And when you prepared the letter, can you describe what you mean by preparing it? Did you write it yourself or type it yourself, or did an executive assistant do that?
My assistant did the typing.
Okay. And did you tell your assistant what to type?
Yeah, I tend to be old-fashioned and handwrite first, to get the truth be done.
Okay. So in this case, did you handwrite the letter and then?
I believe so, yes.
Okay. And Your Honor, may I approach to obtain some exhibits, please?
Yes.
And I'm going to publish what's already been admitted as State's Exhibit 2. And so now I'm publishing what's been admitted as State's Exhibit 2. And I think I will zoom in a little bit. And Ms. Hunterton, what I have on the overhead here, can you see that on the screen in front of you? And can you see that okay?
Comes and goes, but yeah, I can.
Oh, actually, I'll zoom in a little bit more. There we go. Is that good?
Maybe move it, if it's possible, a little bit that way. That's good. That's perfect, thank
And
you.
we'll probably I'll move it down as we, I'll ask you some questions about it. Okay. So, and Ms. Hunterton, on the screen in front of you, if the technology is cooperating with us today, at the bottom of your screen, you might see two different little pen icons. Do you see that? If you look, there's one thing that kind of looks like a red pen, and then there's another one that looks like a pen, but it has a little one next to it.
You have to move the mouse.
Oh, that might help. Okay, try moving your mouse.
Okay. Yes, now I do, correct.
Oh, okay, great. So I may ask you to move your mouse to various points, and then I'll ask you to click on the thing that looks like a pen that has a little one next to it. But if it doesn't work, we'll just roll with it. Okay. So here, so I'm showing you a document contained within State's Exhibit 2. Do you recognize what we're looking at here?
Yes, I do.
Okay, what is it?
It is the letter that wrote at the end of Mr. McDonald's session with me on August 31st of 2017.
Okay. And so up here at the top, is this the name of your practice?
It is, yes.
Okay. And you testified just a minute ago that you addressed it to the court. Is that what's shown here?
That is correct.
Okay. And can you see the date here?
Yes,
Okay, what is the date?
August 31st, 2017.
Would that have been around the time that you wrote this letter?
I know that I wrote it at the end of the session, yes.
Okay. So on or near August 31st of 2017?
Correct.
Okay. And then we're going to move down a little bit, and there's a bit of a shadow, so it might be hard to see, but do you recognize, what are we looking at in this section?
We're looking at my signature and professional identification.
Okay. And is this LMFT, is that your professional identity?
Licensed marriage family therapist, yes,
Okay.
licensed member.
Okay. And this right here is your signature? Is that right?
Correct.
Okay. And obviously, I'm assuming the blacked out section, obviously, I'm correct in assuming that that wasn't there when you prepared the letter, correct?
Correct.
Okay. And you understand I'm not going to ask you about what was in the blacked out section,
I
correct?
understand.
Okay. So could you read the letter for us, starting with Dear Judge Marquis?
Dear Judge Marquis, Michael McDonald has seen me for individual therapy to address issues related to divorce, his personal well-being, and to develop insight related to his separation from his ex-wife and especially his children. We've met regularly since June of 2017.
And then the last sentence.
Oh, please contact me if further information would be helpful. Sincerely.
And then other than the portion that's been blacked out, is this an accurate copy of the letter that you prepared for Mr. McDonald?
Yes.
Okay. And then I'm going to publish what's already been admitted as State's Exhibit 4. And can you see that okay, Ms. Hunterton? Okay. And do you recognize what we're looking at here?
I'm sorry, do I recognize what about it?
Do you recognize what we're looking at here?
Yes, I do.
Okay. And then could you please read this letter starting with Dear Judge Marquis?
Dear Judge Marquis, Michael McDonald has seen me for individual therapy to address issues related to divorce, his personal well-being, and to develop insight related to his separation from his ex-wife and especially his children. We've met regularly since June of 2017. I do not believe Mr. McDonald is a harm to his children or himself. Please contact me if further information would be helpful. Sincerely.
And just to correct the record, I referred to this as State's Exhibit 4. It's actually State's Exhibit 3. So Ms. Hunterton, so the letter you just read, is this the same letter that you prepared for Mr. McDonald?
No, not exactly.
Okay. And can you explain how is it not exactly that letter?
In the paragraph that begins with, that I had written initially, Ms. Michael McDonald, et cetera, there is a line added at the end. I do not believe Mr. McDonald is a harm to his children or himself.
Okay. And could you just try out our technology and get the mouse and see if you can kind of draw a line or circle the information that you're talking about, or the line you're talking about? No, not that one.
Sorry. Okay. Oops.
Well, that's okay. We can make
You want me to go under?
If you want to
Can
try
I
and
do
go
that?
under.
Is there any way to erase it? Go. I'm sorry. I could have underlined
Okay,
it.
I think that's fine.
My apologies.
Okay. So I think we can generally see the area that you indicated there is the area that you've put the red mark on. Is that what was not in the original letter that you prepared? And I'm actually going to go back to the first one that I showed you. Just State's Exhibit 2. Could you, you hit the little trash icon? There should be.
Now it's a clear screen, is that what you want to do?
Yeah, try hitting.
Michael is a lot stronger than he looks.
This one? Oh, here. Okay. So now I'm back to showing you State's Exhibit 2, the letter I showed you at first, and you testified that this was the letter you prepared for the defendant. And so was this letter then provided to you?
Relax, deep breath. Mike,
And how was that done? Email?
relax, deep breath. Mike.
It's given to him in person.
And were you present when that happened?
Yes.
And would it
Just relax, deep breath. Mike, take a deep breath.
I got this, we got this, want to see my kids, come on. I've done nothing.
Mike,
Just take it
calm
backwards.
down. Dude, take a deep breath.
Guys, come on. You're gonna really throw me in jail because I missed my kids, come on.
Assistance in 15 Charlie. 15 Charlie.
Stop, come on, please, guys. Please, I don't want to.
You got it?
Please, guys.
Let's just hold him. Come on.
Mike,
Mike.
stop fighting with the guys.
I'm gonna take her.
Mike, stop fighting with them. You have to go over there and help them with cuffs on you? Don't
Do you
fight with them.
understand? I'm gonna
Don't
tase
fight.
you.
Don't fight with them. With the handcuffs on. Mike, put the fucking handcuffs on. Or I'll put them on myself.
Great, come on.
I'm on your side, Mike, but you're out of line.
This is ridiculous. Like, there was no order saying I can't see my kids. It's a CLA thing.
Mike, just relax, deep breath. Mike, take a deep breath.
It had been given to him around August 31st of 2017.
Correct.
And at some point after this letter was given to the defendant, did he make any additional requests of you regarding letters?
At the end of our session, I believe when she had already typed it, she asked if I would be willing to write something about his parenting. He asked if I would write something about his parenting status. I said, yes, I would have, but that we didn't have time at that point.
I'm sorry, didn't you remember?
Repeat what I said?
Yes, ma'am, I
Okay. At the end of the session where this letter was created, he asked if I would add something about his parenting situation. I said I would, but at that point, this letter was already prepared. And so I said I would soon in the future. Yes, I would have.
Thank you.
Yeah.
Sorry.
And regarding parenting situation, is that the wording that the defendant used?
I don't remember what he said. I'm sorry.
It was over a year ago, right?
What was 2 years ago? Yeah.
Oh, you are. And but regarding, what was your understanding of the type of letter that he wanted you to write in addition to this letter?
One that recommended that he have access to his children.
And were you willing to write such a letter?
I would have written something with what I thought were the appropriate conditions. Yes, I absolutely would have.
Okay. And could you describe in a bit more detail what type of letter you were envisioning it would be?
It would have, said that,
I'm gonna ban you.
while there
I'm
were-
gonna ban you.
if
I'm
there
gonna
were legal
ban you.
concerns as well as personal concerns, allegations or whatever about his parenting, that it would just have to be under supervised situations or whatever. But in marriage and family therapy, we do believe that it is useful for parents and children to have access to one another.
Linus, the lights are too bright today. I can't. Every day I have to sit through 3 or 4 hours of bright lights smacking me right in the head, and today I'm not going to.
Protected and safe, under protected and safe circumstances.
And.
I can't be late.
And
This
how,
is my
how
channel.
lengthy would such a letter be if you were to write it? Just an estimation.
I'm pretty verbose, there probably would have been a big one paragraph or two.
Okay. So fair to say it would have been longer than.
I'm gonna ban you.
Yes.
And Your Honor, may I approach the witness?
Yes.
Terry, don't say hi to him. I'm gonna ban him. I'm gonna ban him. He's straight up bullying me right now. Bullying me.
And Ms. Hunterton, I'm handing you what's been marked. They've been marked on the back. One is State's Proposed Exhibit 8, and the other is State's Proposed Exhibit 9.
Oh, shush, Anthony. I'm not banning you. I love you.
First, so you can take a look at those. First, I want to ask you, sometime in March of 2018, did a detective come meet with you regarding the defendant, Mr. McDonald?
Yes.
Counsel approach.
And I think I'll repeat the question I just asked. Sometime in March of 2018, Ms. Hunterton, did you meet with a detective regarding Mr. McDonald, the defendant? And did he show you those same letters that I just showed you today? And in about April of 2019, did you execute an affidavit regarding the defendant?
I did.
Okay. And what was your reason for doing that?
Somebody in this situation asked that I do it, and I just said what the situation was.
Okay. So you have before you what's been marked for identification purposes, and it's marked on the back as State's Proposed Exhibit 8. Do you recognize that?
This is the affidavit?
Well, my question for you is, do you recognize it?
Yes.
Okay. And what is it?
It is the affidavit that I...
Is it a fair and accurate copy of the affidavit that you prepared regarding
I'm
Mr.
gonna do
McDonald?
your dishes.
And
gonna fold your
when did you
laundry.
prepare that?
It's dated 4/29/18, so I think 4/19/18, sorry.
And, Your Honor, this time the state moves to admit State's Proposed Exhibit 8.
Defense objects.
Approach. Will be admitted.
And now we're going to go to the other document I handed you, which has been marked for identification purposes as State's Proposed Exhibit 9. Now, at your practice, do you or your staff keep records of client visits?
Yes,
And so State's Proposed Exhibit 9 that you have in front of you, do you recognize that?
I do.
What is it?
It is
Oh,
a
I can
client
snowblower.
contact record. It
I can.
indicates the time someone has come and, yeah, and when they don't come.
Okay, so anyone that you have as a client, does it record the date as well as the time that they come or don't come?
Yes.
And so for State's Proposed Exhibit 9, is that a fair and accurate copy of the client record kept for Mr. McDonald?
Yes, I'm not sure it's completely current, but yes.
Okay. Meaning since this record was prepared, there may have been additional client
I think
visits?
it's possible, yes.
Okay. Would this record have been made at or near the time of the dates listed on it?
Yes.
And is it, and I think you kind of just answered this, but I'll ask it anyway, is it the regular practice at Character Way to make a record like this?
Yes.
And was this record kept in the ordinary course of business at Air Fairway? Your Honor, at this time, the state moves to admit state's proposed Exhibit 9.
Any objection?
No.
It will be admitted.
And Your Honor, may I have permission to publish Exhibits 8 and 9? And I am publishing State's Exhibit 8 that's been admitted. Okay. And
I can pay your electric
it's now on the
bill.
screen. Okay. And Ms. Hunterton, could you tell us what we're looking at?
This is an affidavit prepared
You can eat my french fries.
just regarding my my experience with the letter. The letter there.
And I'm just going to ask you to read a portion of this letter, starting here with Michael McDonald, and then just read down to the I hereby state.
Michael McDonald has been a client in my private practice. On August 31st, 2017, I wrote a brief letter indicating he had, quote, seen me for individual therapy to address issues related to divorce, his personal well-being, and to develop insight related to his separation from his ex-wife, and especially his children. We've met regularly since June of 2017, end quote. After giving Mr. McDonald the letter, he asked if I would write another letter saying I thought he did not pose any danger to his children. I said I would be willing to do that and would have given the opportunity. I hereby state that the information above is true to the best of my knowledge. I also affirm that the information here is both accurate, complete, and relevant information has not been omitted. And this is my signature.
Okay. And did you have this notarized?
I did.
as well?
I did.
Okay. And so when you wrote in the affidavit, what did you mean by that you would have been willing to do that given the opportunity?
That's consistent with what I have said before. I would have advocated for
Me too, Remus.
an opportunity for him to meet with his children. But I would have had to write I would have in conscience had to write a letter that evaluated issues of safety and that kind of stuff, which I would always do in a situation like this,
Okay.
where
And that's-
custody is deprived.
So you're describing the type of letter you would have written. So this affidavit that you executed about April 19th of 2018, at that time, did you feel like you hadn't had the opportunity to
Dude, it was one sentence on one document. Let's go, people, please.
write such a letter?
Correct.
And now I'm going to publish what's been admitted as State's Exhibit 9.
Yeah, David, you're going to have to
And can you explain
be more
what-
specific.
These are sessions,
You're a witch, Linus.
status of them. For example, if it says a no-show or late or whatever, it means that they were appointments made but that did not happen, or
For
appointments
fuck's
that
sake, no
did.
charge.
And so does this indicate which client this record is for?
Yes, this is Mr. McDonald's.
Okay. Is that indicated here?
Correct. That's his name.
And then, so the column that says date, which is probably pretty self-explanatory.
Correct.
Is this indicating the dates that you saw Mr. McDonald?
Correct.
And so is this the first date here?
Yes.
Okay. What date is that?
6/28/17.
The June 28th, 2017?
Correct.
Okay. And then, what does it say here?
I think it says late cancel.
Oh, okay, I think I meant right next to 6/27.
Oh, initial, that was his initial session.
Okay. And then we see some additional dates here. Would these dates indicate when Mr. McDonald saw you as a client?
Correct.
Okay. And you see where my pen is here?
Correct.
Okay, can you tell me what that date is there?
That's 8/31/17.
Okay. And since that's the same date on the letter, do you think that was the date that you gave him the letter?
Yes, I do.
And then, and on what date would you have seen him next after that?
According to this, on March 22nd of 2018.
And the next date under that, we see here, what date is this?
11/6/17, I believe.
And what does it say next to that date?
A no-show.
Does that mean that Mr. McDonald didn't show up for his appointment? And then what's the date underneath that?
12/5/17.
And what does it say next to
A
that?
last-minute cancel.
And then, and is this the date you were just referring to, March 22nd, 2018?
Correct.
And then the last date on here?
4/5/18, or April 5th, 18.
And it looks like, is this an I written?
That means an individual session.
Court's brief indulgence. And Your Honor, I will pass the witness.
Prosecutor.
Yeah, I want to understand something here. Mr. McDonald was ordered by the family court when he didn't have a lawyer that he could have no contact with his kids, correct?
Your Honor, I object, that's lack of personal knowledge.
Well, let's rephrase it.
If she knows.
If you know, that's why he came to see you, correct?
That was part of what he told me, yes.
All right. And so you met with him and you formed an opinion that he was in fact not a threat to his kids, correct?
I would say what I thought was that he should be able to see his children.
All right. And after you met with Mr. McDonald and he had a hearing coming up, he asked you to write a letter to that effect, correct?
I was not aware of that, the truth. I was not aware until the very end of that session what he wanted. I thought he only needed indication that he had begun therapy.
Okay. And you remember what you testified to at the preliminary hearing, correct? That you'd agreed to write the letter?
That subsequently I would write the letter, absolutely.
Okay. So the letter that Mr. McDonald turned into the court was actually substantively correct. Correct?
Those would not have been exactly the words I would have used.
Yes, ma'am. But let me ask you a question. Did Ms. Mishler have you actually read what you testified to before a preliminary hearing?
You show me, please.
Okay. Would refresh your recollection to what you testified to on a previous occasion on oath.
Okay.
Ms. Mishler, this would be from the preliminary hearing transcript of August 7th. This would be pages on cross-examination starting 23 through, appears to be just 27. Okay, approach, John?
Yes.
Any of the preliminary transcript, ma'am, starting here where it says cross-examination begins, would you just take a few moments to review that and see if it would refresh your recollection as to what you previously testified to under oath?
Wait, why are we having her read her entire cross-examination?
Because it's actually about.
Oh, he was just asking if it refreshes your memory.
Well, she remembers testifying.
It's 4 pages, it should be done in a minute.
I'm sorry.
All right, and I see that you're nodding your head.
Actually, sir,
All right. Are you done reading?
let me just go there.
Sure. having reviewed your testimony at the preliminary hearing, does that refresh your recollection as to what you testified to under oath at a previous occasion?
Yes,
All right. Now, was it your opinion that Mr. McDonald was not a threat to his children?
what I believe I testified to was that I would write a letter advocating for his right to see his children, even as I read that now. I don't mean to be difficult, but.
All right. Now, have you, and I know what a marriage and family therapist does on a day-to-day basis, do you get involved in court proceedings?
I
or-
have, in the past, I did a great deal, I do not do it.
Okay, so you're kind of off and aside, the courts, you keep the courts at arm's distance?
Correct.
Okay. Now, did Mr. McDonald tell you that he had a hearing coming up on his family court case in a few days after your session? Do you remember that conversation?
One of the difficulties is, I only knew that he needed a letter. It does not make sense to me in this moment that if I knew he had a court hearing to that effect, that I would not have addressed that issue. I wrote that during our session.
Yeah.
So I don't believe I was aware until the end of the session, which it does say in there.
And you agreed to write the letter for him, correct?
I said I would write a letter, yes.
Okay. Now, did you in fact get a chance to write that letter?
He never, didn't come back with a letter, no.
Okay. And we asked you directly on the direct examination and preliminary hearing, you said, yes, ma'am. So factually, there's nothing in that letter that you would have written differently. I understand, but factually, the document itself is actually your opinion. And your answer was? Do you remember what your answer was?
No, I know that I say yes, I understand, in my testimony that I.
All right. So regardless of how the letter was written, you substantively agree with the letter as it was presented. That's what you testified under oath.
Well, I do understand the legal ramifications of it, but I also, you're also asking me
Ma'am,
to go.
I asked you, I'm not trying to be.
Yes,
here.
yes,
I
the
asked you a
answer
very
is,
simple question.
that is correct, yes.
Okay. Now, who's Nina? Did you have an assistant?
No,
You didn't have a secretary or a shared receptionist with somebody?
no, I have an assistant, but her name is not Nina,
All right, what is her name?
Laura.
Laura, was she working with you at the time as well?
Yes.
Okay. And did she or did you go out of the country shortly after this last session with Mike? Is that why you were a little pressed for time to get that letter done?
No, I think he had come very late, and then it was a Friday afternoon or whatever it was. We were just trying to.
Finish up the day?
Yes,
Okay, so I'm gonna just want to make you understand. He asked for a letter, correct?
but without full explanation of what it was for.
You agreed to write the letter, correct?
I wrote the letter as I understood it was supposed to be. Then as he was leaving, he asked for something else. I said I would do that.
And you agreed that both the preliminary hearing and here, that the opinion in the letter was actually your opinion,
It does say that there, yes.
all right? So, when the detective came and handed you this letter, there was nothing substantively incorrect. Stylistically, but substantively incorrect.
I think the question was, did I write that? I don't mean to be difficult, but
And have you ever done any legal work?
I've been foreman of a couple of juries, and I've been related to lawyers, but no, I haven't.
Have you had to prepare any legal documents or file them?
Oh, of course.
Okay.
I only write in cursive. It's way faster.
I don't think I've done it in a very long time. I
All right,
haven't
thank
done it
you.
at all.
Now, after the detective came and saw you, did Michael continue to visit with you?
Yes.
All right. And what was the name of the detective? Who was there?
I think the first name was Matthew.
Matthew? Was it? You don't remember?
Let me see if I write the test.
I know it's in the larger file, I'm sorry, I don't have it.
All right, ma'am, and when you talked to the detective, did you talk to substantively about Michael's therapy? No. What was it that the detective was interested in?
Having me identify which of the letters I've written.
Counsel, you had previously had the affidavit, where was that?
That was up there. No, it's on the podium.
Oh, thank you, Mayor Pro Tem.
I am fighting back the urge to just fast forward.
It's on the back.
Oh, thank you. We'll get the court's indulgence for this moment. Thank you, ma'am. I don't appreciate your patience. I'm sure I don't mean to be difficult, but...
I don't think I can help you.
Redirect.
Just briefly, Your Honor. Ms. Hunterton, the letter that you gave the defendant on August 31st of 2017, did you ever give the defendant permission to alter that letter? Did you expect him to alter that letter? And you were asked some questions by defense counsel about your testimony at preliminary hearing. Your Honor, may I approach the witness with a copy of the preliminary hearing testimony? And for the record, I'm referring to page 24 of the preliminary hearing testimony. And Ms. Hunterton, so I'm showing you, this is slightly bigger font, so it might be easier to read from, but I'm showing you page 24 of your preliminary hearing testimony. You recognize it as the same thing defense counsel showed you, right? Just bigger font, okay. Do you see a question here? Could you just read this question here?
Yes, ma'am. You're referring to what line?
I'm about to say that. Line is 6 through line 8, please, on page 24.
Regardless of the origin of the document, where it says he's not a threat to himself or his children, do you agree or disagree with that assertion?
And then what was your answer?
I agree with it. If I had written it, I would have written more to explain my position.
Thank you. Nothing further.
Nothing further, Judge.
Questions from the jury? Raise your hands. No questions? No questions. Thank you. You may step down. State, call your next witness.
Here, the state called Brett Sagaski. The building?
There is.
And is there some sort of hub or room where those videos can be monitored?
Yeah, there's multiple locations throughout the building that can be monitored.
And that's a regular part of your duties to monitor those videos?
Yes.
Do you do that on a nearly daily basis?
Maybe not every day, but weekly.
And do you know where all the cameras are located and how they function?
Pretty familiar with this.
All right, she might be, free with her therapy, laid back, out of the box, but this is a court case. And he falsified her document in a court case. So, yeah, that she should be livid.
I want to draw your attention back to December 4th, 2017. Were you on duty working in this building on that day?
I was.
And specifically, were you monitoring video surveillance on that day?
I was.
Were you made aware at some point on that day that there was a person of interest in the building?
That's correct.
And what was that person's name?
Michael McDonald.
Do you see that individual in the courtroom today?
I do.
Can you point him out and describe an article of clothing that he's
He's
wearing?
wearing a white t-shirt at the table to my left.
May the record reflect the identification of the defendant, Your Honor?
No, sorry.
Can we approach?
Yes. Apologies. After you were told who you were looking for, were you able to locate the defendant within the Regional Justice Center on video surveillance?
I was.
Is it true that you've never met or spoken with the defendant,
I have not.
including on that day, correct?
Correct.
Did anything further happen that day that necessitated you to come in contact with the defendant?
No.
After you had located on video surveillance, was any portion of that video saved?
A screenshot of one of the videos was saved.
And can you describe what you mean by a screenshot?
Pause the video and then take a screenshot of what appears on the computer screen.
And where did you save that screenshot?
To one of the files from that date and time.
And why did you do that?
Just to show that if I located him, didn't see anything out of the ordinary, so just took a screenshot and saved it. There was no reason to maintain the video.
Original approach here. Please grab it. Showing defense counsel proposed exhibit 12, Your Honor. Mr. Approacher?
Yes.
Sergeant, I'm showing you, it's been marked as proposed exhibit 12. Do you recognize that?
Yes, that's the screenshot that I took.
On that day, I know you've made clear that you use that video surveillance on a nearly daily or weekly basis. Was the video surveillance working in proper order that day?
The cameras that I observed were working properly.
And using the video included this screenshot, you were able to identify the defendant in the building that day?
That's correct.
And you recognize this as a screenshot from that video from December 4th, 2017 that you yourself saved in a file?
Correct.
Were you at some point later asked about that video and happened to remember that you had saved this?
I was subsequently questioned on whether there was surveillance that existed from that date and time.
And what did you do when you were asked about that?
I checked to see if surveillance was available, and it was not. And then I checked our file to see if anything had been preserved from that date and time. And this was the item that had been preserved.
The state would move to admit proposed exhibit 12, Your Honor.
Objection is relevant.
Approach. The objection's overruled. Have a good noted.
Thank you, Your Honor. Permission to publish?
Go ahead.
Showing you what's now been admitted as State's Exhibit 12. Do you recognize that as the screenshot we've been discussing?
That's correct.
So I see that on the screenshot itself, we don't see a date or time. Is that correct?
That's correct.
When you survey video as it's unfolding, or when you say the video, does it have date and time?
Typically on this program off to the right side of the screen.
Okay. Is this screenshot, has it been zoomed in?
Correct.
And is that why we don't see a date and time stamp?
That is correct.
And again, I know you testified that this was taken while it was in the Regional Justice Center, but do you recognize the floor pattern specifically depicted there as being out of the Regional Justice Center?
That's correct.
Brief indulgence. Nothing further, Your Honor.
Cross.
No questions.
Questions from the jury? Raise your hand. No questions from the jury. Thank you. You may step down.
anticipate Mr. Speeds would testify along the lines of the fact that he's seen Mr. McDonald sort of protesting or being involved with watch groups that are watching and publishing content regarding the family courts. None of that is a bad act or a crime.
I'm a little concerned, this is starting to sound an awful lot like we don't like your politics, Mr. McDonald. There's a very specific theory of criminality here. And specifically, that he went in on that day to do something illegal. If he's there every single day, how are they going to prove
I
that
am
that particular day
very
to do
bored.
something illegal?
Yeah, I'm gonna allow the officer, so you need to bring him in and talk, or go and talk to him, that he sees them a lot, he's there on other cases, he's there for other reasons, so he recognizes them, but the fact that he's there, I assume outside protesting, I don't see the relevance of that. You want to show, you're allowed to show that he knows who he is, and he was there on that date, fine, but I don't see the relevance
Yes, that's why I played that music. I was just setting it up.
to whether or not he's protesting, etc.
And Your Honor, I anticipate what the witness would say, that maybe not use the word protesting, but he would say that he's observed the defendant observing other family court cases in addition to this. Is that fine?
That's fine, that he sat through other cases, he's seen him many times sit through all kinds of cases, whatever, but the protest, I don't see any, assuming that's what the characterization is, I don't see any relevance to that, so you can both go and explain that to him.
Thank you, Your Honor.
They see that the parties acknowledge the presence of the jury.
Yes, Your Honor.
Yes, Your Honor.
And that's a great breaking point for today. That's as much as we can handle in one day. There is, oh no. There's an hour and 20 minutes left in this video, but maybe it'll get better tomorrow. We'll see. Listen, they can't all be him getting tased. Come on, guys. Yeah, I set up OJ. It's gonna automatically kick you over to OJ in about 3 minutes. Guys, thank you so much for coming out today. I appreciate it. I'll see you in 3 minutes in OJ. Bye.
Got these life that goes digital dreams through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes mirror sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts song. In a way, there's no